All right. Court of Appeal in for the 5th District, State of Florida is now in session. The Honorable Wendy W. Berger, Judge, presiding. All persons having visited before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to a session of oral argument here at the 5th District Court of Appeal. We have 4 cases, I think, on the calendar today. After the first 2 cases, we're going to have a panel change, and so we'll take a break after the first 2 cases that are on the calendar. Joining me on the panel today is Judge Sawaya and Judge Wallace, and we are honored to be hearing the cases that are set for today. If any of you have a cell phone, I noticed I had mine in my hand, and I put mine on silent. If you'll put yours on silent or vibrate or turn them off, some way that if they start to ring, we do not hear them. And we're going to begin today. We have 2 civil cases this morning. Each side will have 20 minutes. If the appellant will just let me know ahead of time how much time you'd like to save for rebuttal, then I will set the clock accordingly. You'll see a little light up there, green light when you're during your time. A yellow light will come on when you're into your rebuttal time, and then a red light when your time has expired. The first case we have today is Carter Tabernacle Christian Methodist Episcopal Church versus American First Federal. Whenever you are ready. Well, there you go.
Good morning.
How much time would you like for rebuttal?
If I could reserve 3 minutes, Your Honors.
3 minutes? Okay. All right, you may begin.
Good morning, Your Honors. May it please the Court. My name is Mike Tessitore, and I represent the appellant, Carter Tabernacle Church. I won't go through the full name, it's a long one. Carter Tabernacle is a 100-year-old African-American church located in the Pine Hills area of Orlando, Florida. The action below resulted in a foreclosure judgment being entered on the church's facility, consisting mainly of a sanctuary, classrooms, a nursery, and the church offices. And as a result, and unfortunately, the church was forced into a Chapter 11 bankruptcy proceeding where it currently remains. The case stems from...
Is the usury issue a strong issue for you?
I believe it is, Judge Sawaya.
Because the loan modification agreements had a savings clause. And if you calculate it out the way you calculate it out, it seems as though that if it exceeded the upper limit of the rate, that it was basically de minimis. Are those factors that can be considered in determining whether there was corrupt intent? Which I think is a necessary factor that needs to be established, right? You agree with that?
I do agree with that,
Okay.
Your Honor.
Well, those 2 factors that can be considered in determining whether there was corrupt intent?
Certainly, those are factors that can be considered. The savings...
They were established in this case, right? I mean, the loan modification agreements had a savings clause, didn't they?
They had a savings clause. The case law indicates that those are not determinative.
No, they're not, but it's a factor that can be considered.
It's a factor that can be considered. And in terms of whether the amount was de minimis, we're talking about an interest rate of 25%. We're at the loan sharking criminal usury rate.
How much in excess of the 25% do you calculate the interest rate exceeded?
It would have been, the trial court found that it was approximately $2,000 and change at the...
percentage, 25 point what percent?
25.34% is the...
That's not a large excess, is it?
If you're committing what is essentially loan sharking, any amount of a loan sharking, essentially a crime, to me is a serious matter.
So
Whether
if
it's two,
0.00001% in excess, I mean, that's loan sharking, and that wouldn't be a factor that would be considered. And
if you're engaged in loan sharking, the policy of the state of Florida is that's absolutely prohibited, and there are very serious repercussions that go along with
To
that.
what extent, though, do we consider the testimony which of, that was discovered by, it was a mistake, it was discovered by the bank, and the bank corrected it
And
on their own?
Yes, Your Honor, and that's a very important issue. The documents themselves, I think it cannot in good faith be disputed that the rate that was calculated and sent to the borrower, to the church, is perfectly consistent with what's mandated by the loan documents. So in other words, if you take what the loan documents say, you calculate the interest, you end up with the rate in excess of 25%. So the alleged accounting error is that we made an error by not following our own loan documents and correcting this 8 years ago, back in 2005, and that we therefore kept sending out statements with the usurious rate. The problem there is the fact that you may have committed an accounting error doesn't change the fact that
well, if there's a savings clause that says that the interest rate may not exceed the lawful rate, is there any responsibility on your part to make sure that that is enforced in the loan documents? I mean, and if you don't, is there such a thing as a waiver?
Well,
is there anything in the record that indicates that you took steps to see to it that the savings clause was enforced in the modification agreement?
I don't think the church was aware.
Pardon?
I don't think the church was aware that they were being charged a usurious rate. They went into default. They went from a very lucrative rate of interest for this lender who acquired this loan.
Does the usury statute even apply in loan modifications where the loan is modified based on prior default?
I believe it does. The loan modification is not a debt instrument. If you read the loan modifications and if you read the plaintiff's complaint.
What was the purpose of the loan modifications? The loan modifications was to allow the loan to remain in effect because of the prior default of the church, right?
That is correct. And it was definitely a two-way street, the loan modifications, because as a result of that, the 25% default interest provision was put in there. The bank and bank's representative testified to this. They earned handsomely on the loan modifications because they had a multi-million-dollar in loan in default that was earning rate at.
Oh, you gained as well because the loan remained in effect and you didn't lose the property by a foreclosure.
We did, Your Honor, and the law in Florida is very clear. This church could have been complicit in the usury, and that would not prevent a finding of usury.
And there were multiple loan modifications, correct? There
were multiple loan modifications.
And your client was represented in those negotiations as far as those modifications, correct?
I wasn't involved in, Your Honor. I believe that to be correct, but I'm not 100% sure.
So pursuant to, as Judge Savoy was getting at, pursuant to those modifications, your client was able to maintain a business relationship or maintain their church for quite a period of time. And that was an advantage they gained from the loan modifications. Correct?
That is certainly true.
Was the interest rate the same in each of those loan modifications?
The default interest rate was definitely the same, 25% plus 25 and change in excess of the usurious rate. Thank you, Your Honors. But if I maybe could go back to Judge Berger's question about the accounting error, because I think this is what the trial court focused on in finding that there wasn't corrupt intent. The testimony was undisputed that Brett Johnson, the bank representative, reviewed each loan statement, which had the usurious rate in it on its face, verified that it was correct, sent that to the borrower, and expected them to pay those charges. Now, this is years after this supposed accounting error. So if you have a bank officer that's looking at the document, seeing the usury, sending it to the borrowers and saying, you must pay this, you are legally bound, and that was his testimony. His testimony was they were legally bound to pay the charges on those documents, and this is on multiple occasions as set forth in the testimony. In addition, there was a prior foreclosure
Well,
case.
at that point, did you raise the savings clause, which clearly indicates that they can't exceed the lawful rate of interest?
Did the church raise that? No, I don't.
Did you tell the bank that? I mean, you can't exceed the lawful rate, therefore you're charging too much?
I wasn't involved, but I don't think the church knew, frankly. They just paid. They paid whatever the statement said, including multiple payments that included the usurious amount. And what's interesting, and I don't know if this came through in the record, is there was a prior foreclosure where the interest was specifically calculated for that foreclosure and a complaint filed, including the usurious charges. So this is not a situation where there was an accounting error made years ago, nobody knew about it, and then they discovered it later. There was an accounting error made, people were looking at the documents, calculating the interest at the usurious rate, sending it out to the borrower, filing a foreclosure, and demanding that it be paid. So the fact that you made an accounting error doesn't somehow eliminate the possibility that you've got intent later on. And I think the phrase corrupt intent, if you read the case law, is a bit of a misnomer. All that is required is that the lender know that they are charging the interest rate, which is unlawful. In other words, it's not an intent to charge an unlawful rate. It's not an intent to harm the borrower. It's an intent to charge the rate, in this case 25.3%, which happens to be...
You characterize it as an accounting error. If somebody just makes a mistake, that doesn't necessarily equate to corrupt intent, does it?
I actually don't believe there was an accounting error because I said the rate is perfectly consistent with what the loan documents require. It was the
rate after default?
Yes.
So,
and there's one other key factor here. When the second foreclosure was filed and the final demand letter before the foreclosure was sent out, apparently they decided to change and take out the usurious interest. And they sent a new demand letter to the church. Guess what they didn't do? They never mentioned anywhere in that letter that they had been charging the rate in excess of the legal rate. They never admit that they had deducted out.
You didn't know, maybe they didn't catch it as well. Maybe they didn't realize it was.
Except that their bank officer testified that he reviewed every statement before he went out and that it was accurate. And he understood what was in it, and he demanded that it be paid.
Okay.
If I could maybe address the lost note issue, if that's appropriate at this time. Your Honors, I know you're probably familiar with the requirements of Section 673.30911 for reestablishing the lost note, and those are that the party seeking to enforce the note must prove that they acquired ownership of a person entitled to enforce the note when the loss occurred, and that the loss was not the result of a transfer or a lawful seizure. Importantly, and the case law is very clear here, and there's two Fifth DCA cases right on point. The statute requires testimony from a witness with personal knowledge to satisfy those elements. And there's two cases that I think are determinative of the outcome of this case as it relates to the lost note, and that is the home outlet case versus U.S. National Bank at 194 Southern 3rd, 1075. That's a Fifth DCA case. Figueroa versus Fed National Mortgage at 180 Southern 3rd, 1110. In both of those cases, the lender offered a representative to talk about.
I've often wondered if you have loan modification agreements that modify the terms of the promissory note, doesn't the fact that you signed the loan modification, isn't that evidence that of what the note said and that what it provided? And you're really going on the loan modification agreement rather than the original promissory note, right?
It could be, Your Honor, but it depends. A loan modification can be an independent debt instrument that creates a new debt, and a plaintiff can sue on that. That's not what happened in this case.
Well, I mean, you had a drastic increase in the amount of the interest, right, from the original note because now you're claiming the interest rate was usurious.
It modified the loan terms, but it did not create a new debt. If you read the loan modifications, they rely on the existence of the renewal promissory note.
But if you have a modification agreement that says that you owe X number of dollars as principal and you're going to pay X number of dollars as interest and you're going to pay X number of dollars per month until the principal amount is paid, doesn't that kind of supersede the note? And doesn't that basically establish that there was a promissory note and what the original terms and conditions are that have now been changed? And really, when you sue, you're suing on the loan modification agreement, aren't you?
They did not sue on the loan modification. It was never pled. It was never argued at trial. And more importantly, the loan modifications at issue in this case didn't create that type of new debt. They simply modified the terms of the original note. And the reason you have to reestablish the original promissory note, the original instrument, is because that's a negotiable instrument.
Yeah, no, you don't want it changing hands and somebody else getting hold of it and trying to enforce it, right? I understand that, but
there's no exception in the statute for having to reestablish that underlying debt instrument, which is an instrument.
That's the primary purpose for reestablishing.
That's correct. And they did not plead any of the things that Your Honor is suggesting. They never argued that at trial, nor would it get them around the fact that the underlying debt instrument, if you read the mortgage and that's why they brought the case the way they did, is because if you read the modifications, they are still.
So you're saying they did present sufficient evidence to establish the lost note?
They did not. And in fact, if you read the Figueroa and the home outlet cases, the lenders' representatives said things such as, when asked on cross-examination, what do you know about the lost note? What I know is we didn't find it in the file when it got transferred to us. And
was there testimony that was presented that the note, that the note hadn't been surrendered to anybody else or hadn't been, taken by legal means or anything like that?
Here's the testimony, and it's wholly inadequate. This is Margie Flight. This is the only representative offered to reestablish the note. Good morning, Ms. Flight. She responds, good afternoon. Who had possession of the original note when it was lost? I don't know. You don't know who had possession when it was lost? No, not at that time. It was just not placed in the file when our file reviews were placed. So your entire testimony that the note was lost is based on you reviewing the Wachovia file and the note not being there. Correct. You have no idea how the note was actually lost and who lost it. Is that right? It could be several reasons, but you don't have personal knowledge. Correct. Any idea how this note was lost? Correct.
I mean, I hate to state the obvious, but if you knew how it was lost, it wouldn't be lost, correct? I mean, there's no way people are going to know how they lost a note or where the note was lost. If the note is lost, it's lost, and I don't understand, it's like having to prove a negative.
Well, what would happen is that if a note was lost, typically there'd be a business record made of that and put into the file, and that becomes then an admissible record evidence. Or somebody who was managing that file would have seen the note, and then later it was gone. And they would have personal knowledge that the note was in the file, and then it was lost. There are ways to prove the elements, and lenders obviously are doing this in foreclosing all the time. But simply saying that I'm a subsequent person who acquired this loan, and I picked up the file, and it wasn't there, is not sufficient evidence. You have to offer some sort of business record, some sort of testimony, and this is not my interpretation. This is the mandate of the home outlet case and the Figueroa case.
Well, there was also evidence that it wasn't taken by legal means, and that And in addition to the evidence that it wasn't contained in the file,
I'm not sure what evidence you're referring to, Your Honor.
well, wasn't there testimony by Mr. or Mrs. Flight or somebody named Flight that indicated that, that she reviewed the records and there was nothing indicating that the note was taken?
Exactly. She reviewed the file and there was nothing in there. That was her testimony. And they tried to offer that as proof. You can't offer the absence of a business record a proof of anything unless you first establish as a foundation that it is a record of the type that would normally be maintained. I objected to the admissibility of that testimony. That's one of the hearsay rules for the exception to the business record. And there's a specific hearsay rule dealing with how you prove the absence of a record as proof of the non-occurrence of an event. They could have done that. And what they should have done is they would have brought in a witness that said, if we typically maintain a record that says X, and it's not in here, therefore that indicates that the note was lost. They didn't do that. They didn't lay that foundation. And yet that hearsay testimony was admitted. A straight violation of the hearsay rule on how you admit the proof of the absence of a business record. I objected to that at hearsay, and that testimony came in.
So the trial court ruled that the note had been lost and had been reestablished, right? I mean, did the trial court rule that the note had been lost and it had been reestablished? That there was sufficient evidence to reestablish the note?
Without making any findings of how that is possible.
I mean, but did the trial court rule that the note had been lost and had been reestablished, that there was sufficient evidence to establish that?
The trial court ruled that the plaintiff...
And so now you have a judgment that says that the note has been lost and reestablished and that the note and the mortgage are now being foreclosed, although the note had been subsequently amended by the loan modification agreements, right? So you're protected by the final judgment, which indicates that the note has been lost and reestablished, and therefore nobody else can take the note and use it, right?
That judgment...
Is that protection for you or not?
No, Your Honor.
You said that was the primary purpose of the
No, Your Honor. No, I'm sorry.
Go ahead.
I apologize. We're not protected from a third party who may have acquired the note and owns the original instrument. They're not bound by a judgment in a proceeding that they're not a party to, and that's a negotiable instrument, which means that they take it free and clear.
Then in any case where a lost note has been, the court declares it lost and then reestablished and then forecloses on the note and the mortgage, then anybody that has the original note, you're saying, can come in and seek to enforce it.
That's exactly correct, and that's why the statute requires stringently what it does. Because what happens is...
What's the purpose of a cause of action to establish the lost note?
The purpose is to make very, very, very sure with competent evidence.
The purpose is to obtain a judgment that says that the note was lost, but now it's been reestablished and it's being enforced in a foreclosure action. And in that final judgment is some protection to you in case somebody else has a copy of has the original note, right?
It's some protection. It's not much comfort. When a plaintiff shows up and says, I am a holder in due course of this promissory note, I can enforce it, and you have no defenses against me, because that's what...
Exhausted your time, so.
Okay, but that can happen in any case where let's assume there was sufficient evidence that the note was lost and then reestablished. That can happen in that case, too.
That is true, and what... Yes.
All right.
Thank you, Your Honors.
May it please the Court. My name is Mark Chapman. I'm with the Dean Meade Law Firm, and I represent the appellee in this matter. Because I know the Court has already briefed on everything, I won't give any background facts, and we'll get right into it.
What is your position on the usury statute being applied to loan modifications that were modified based on prior default, where essentially you're, including some sort of a penalty by an increase in the amount of the interest rate that's going to be paid? Does the usury statute apply to those types of loan modifications?
Your Honor, we've argued that it doesn't apply to those type of loan modifications, but we've stated, even if it does, the judge heard testimony for an entire day. on corrupt intent. And as this court knows from the Dixon case, which provides the existence of corrupt intention is in the lender's mind. It's a good faith versus bad faith decision. The Dixon court stated, the parties can testify as their purposes and intentions and look at and this is important, the entire transaction. The trial judge is entitled to look at the entire transaction. Here, Business Court Judge Munyon, her testimony from the plaintiff's in-house accountant person who said, we figured this out in May of 2014. We immediately changed the numbers and we sent the new numbers to the mortgagor. And what's important also, Your Honor, is there's zero evidence in the record that there was any of this alleged usurious interest ever paid, this 0.3472%. In fact, there's no evidence in the record that there was any default interest ever actually paid by the mortgagor. Judge, you ask about this being de minimis, or was it just over a certain amount? In fact, Judge Parente on the Florida Supreme Court stated when they were arguing whether a maximum interest clause or a savings clause was a factor in determining whether there's corrupt intent, the court not only said it's not dispositive, but it's a factor. Judge Parente, and they used her illustration specifically and said, where the actual interest rate charged is close to the legal rate, a strong showing, meaning of corrupt intent, must be made to invalidate a savings clause. Just the savings clause here would invalidate any of the any of the defendant's affirmative defenses or counterclaim. But we have more evidence than just that. The judge can look at the entire transaction. As I think I inferred from the questions being asked, the interest rate was 7.88%. As part of the negotiations, and I will tell you in the record, I asked Dolores Batson, the corporate representative for Carter, if they were represented by counsel during all of the legal negotiations. She stated that they were, so they had legal counsel the entire time. The rate was dropped from 7.88% to 7%. That's more than the alleged usurious default interest rate. Modified the loan 2 times. As Mr. Tessitore testified, it was in foreclosure in 2009, and my client had no obligation to modify the loans. It worked with them for 5 years, had 2 modifications, had a First Amendment, lowered the main principal interest rate. It offered $380,000 to $420,000 of reductions in agreements if Carter could make certain payments just over a 10-month period. It was simply unable to do so because, in our opinion, it simply couldn't afford the property that it's on, which is unfortunately still our opinion. It lowered the amounts of the mortgage. Your Honor asked about, didn't it change the numbers? The modifications did change the numbers. It lowered the amount by $199,000. We said, okay, if you'll enter the modification, we'll essentially give you a $200,000 reduction. How anybody could draw corrupt intent from that entire transaction for an accounting error, and the only testimony in front of the court that's on the record is that there was an accounting error that was corrected by my client prior to being notified by the church. When this usually comes up is you filed suit, the other side raises that, and then you correct something. Our client figured it out in advance, sent them a new demand letter that said they'd never sent it before.
What is
Yes,
your
Your Honor.
response to their argument that you did present sufficient evidence to establish the lost note?
Your Honor, we did in fact do sufficient evidence. The cases, and I'll use the cases from this 5th DCA that the appellant has cited. They mentioned the Figueroa case and the Home Outlet case. In this case, Your Honor, which are completely distinguishable from those 2 cases, the only witness called in those 2 cases on which the reliance for the entire opinion is they called their own loan servicing agent. We called Brent Johnson. He was the individual that worked for our client, okay, that came in and said, here's what's owed, and here's what we did, and here are all the modifications we did, and here's why we didn't have corrupt intent. We called Margie Flight, who was the actual loan servicing agent for the entity, Wachovia, that we obtained the loan documents from. In Figueroa, this court stated Fannie Mae, who had gotten an assignment, who had purchased that from SunTrust, the loan documents, called their own loan server, failed to introduce any documents into evidence, had an assignment that was dated after the foreclosure was filed, admitted that they never reviewed the SunTrust files, specifically stated did not review the SunTrust files regarding to see whether there was any evidence of a seizure or a transfer. There were no questions on direct about the lost note. So that clearly wasn't established in Figueroa. In our case, Your Honor, we called Margie Flight, who was with Wachovia at the time, and here's the key, okay, here's what they keep glossing over. This was a merger. Wachovia didn't purchase the loan documents from SouthTrust. It simply became SouthTrust. When that merged and we entered the merger, there's no objection. When a bank merges with another bank, it doesn't have to get a lost note affidavit. It doesn't have to get an assignment. It stands in the shoes at that time. Margie Flight testifying on behalf of Wachovia is testifying on behalf of SouthTrust. You couldn't work otherwise from a merger standpoint. So Margie Flight testified that she looked into the file and looked for anything that would be any indication of whether or not it was lawfully seized, whether it was transferred to anyone, what happened. Mr. Tessitore asked her on cross, do you know whether, and this was their big argument in their appellant brief, do you know whether it was lost by Wachovia or by SouthTrust? And she said she didn't know, which is the honest truth, because nobody knows when it gets lost. And he immediately said no further questions and sat down, because SouthTrust isn't SunTrust Bank in the Figueroa case, because it didn't assign that mortgage over to Wachovia. The other case, the seminal case on point that's argued all the time by mortgagors is the home outlet case by this 5th DCA. In that case, again, First Horizon Bank assigned and sold, and had already filed a foreclosure, assigned and sold the loan documents to U.S. Bank. U.S. Bank called one witness for its entire trial. The one witness was a loan servicer. The loan witness had a lost note affidavit from the prior entity. It was never introduced into evidence. And this court stated the testimony was relied solely on the prior servicer affidavit that was not introduced into evidence. So there was nothing in home outlet from which you could establish a lost note. Here, we called the actual person from the originator, which is SouthTrust Wachovia, who fortunately happened to be there for 31 years, her entire career, which she testified to. And she stated, which was part of her duties, was to look in there and see, did she see any evidence? If there's a more stringent requirement put on a bank or a financial institution to try to establish a lost note, to actually call the person who was there at the time of the merger and who looked into the file, Mr. Tessitore testified, well, from the business record standpoint, you would have to go in and say, well, there would be a business record in there. Well, there was no questions about whether there would be a business record or not. Her testimony was, I looked in there was no indication whatsoever that there was anything misplaced or transferred or unlawfully seized. So clearly, the note was lost. Putting an overly burdensome, stringent requirement on a bank, certainly they should have to, as Judge Sauer, and I apologize if I'm pronouncing that incorrectly, as he asked, the primary purpose of this entire statute is to obviously prevent somebody else from coming in and saying, I have this note, or I have these loan documents, and I'm going to enforce them against you. And here, that purpose is taken care of. You had Margie Flight come in and testify to this, who really is the original loan officer. And we mentioned in here, Your Honor, the statute of limitations had already run I think there was an argument by opposing counsel that we had raised issues in our appellee brief that weren't raised at the trial court. I'm sure, as this court probably knows, from the Tipsy Coachman rule codified by the Florida Supreme Court in Malou versus Security National Insurance Company, Florida Supreme Court 2005, an appellee can present an argument supported by record evidence, even if not asserted in a lower court, because an appellee is not required to raise and preserve alternative grounds for a judgment in order to assist them, because appellant attacks the judgment on appeal. So, contrary to Carter's argument, as this court stated, in Beaumonte versus HSBC Bank, a mortgagee has no requirement to present a witness to testify as to where, when, and how the renewal note was lost. The appellant is arguing Ms. Flight can't testify when it was lost. Well, that's correct. She can't testify. I doubt anybody could get up and testify when it was lost, but it was clearly lost during possession by South Trust or Wachovia, which is the same entity once those entities merged. That loan document was transferred from Wachovia to our client. We recorded an assignment. We got a lost note affidavit. This court has testified has written in Figueroa and in Outlet that the mortgagee would be required to either have a lost note affidavit or call somebody to testify. We had both in this case. So to answer your initial question, Your Honor, we absolutely believe we properly established the lost note and had standing to bring the foreclosure action on the renewal note. And we believe that Judge Munyon, after hearing the testimony of Margie Flight, could weigh her credibility. If she didn't believe Margie Flight was telling the truth or she had any issues, then she could have made that written ruling as part of her final judgment. Additionally, Your Honor, I will state, with respect to appellant's argument, they called a couple of church witnesses to testify and presented no other evidence. There were no interrogatories that were executed by us, ask us. There was no deposition transcript or impeachment from Margie Flight or our client. There was no deposition testimony of any kind put into the record. It's clearly it was the appellant's burden of proof with respect to the usury matter. And again, there was simply no evidence whatsoever of usury other than what we actually placed on with respect to corrupt intent. Your Honor, the appellant has argued with respect to what could happen if that note was lost and who could take it, that there was a parade of horribles kind of defense that could happen to the note. It implied that my client had a duty at trial to present testimony addressing all of the things that could have happened to the note and determining it complied with 673-3091. And Carter presented no evidence opposing Ms. Flight's testimony and no deposition testimony on cross-examination to impeach her. So they had the opportunity to do that, and they had the opportunity to go through any of those issues, and there simply wasn't any evidence to support what their position is on the lost note. And in fact, as this court knows, circumstantial evidence can also be used, which the court heard from the testimony related to the modifications. In the modifications, Your Honor, because one of the concerns, again, is the primary purpose. In the modifications, the mortgagor stated that, yes, we admit you're the note holder. Yes, we admit these are the amounts that are owed, and even additional circumstantial evidence that we're clearly the note holder and have proven that we're the note holder while they were represented by counsel the entire time. During the prior foreclosure, they certainly could have raised that there was any standing issue in 2009 while they were represented by counsel. It was raised for the first time in 2014. Still have a couple minutes left, Your Honor. I apologize. I'll look at my notes and just see if I have anything else.
I don't believe any of us have any questions.
Then I will not certainly waste any more of the court's time. The appellee request that the Judge Munyon's final judgment be affirmed. Thank you.
Thank you. And you exhausted all of your time because Judge Sawaya was asking you some questions, so I'll give you a minute if you want to rebut.
Just want to quickly address this issue of the merger and how I think that that's really a red herring. The note originated with South Trust. Margie Flight did not work for South Trust. At that time, South Trust was a separate legal entity. The note was presumably in some file that she had nothing to do with and no responsibility for. After the merger, that's when the file came to her, and that's when she did this review. So this is no different substantively than the Home Outlet or the Figueroa case.
Except that in that case, the lost note affidavit was not admitted into evidence. And we have the lost note affidavit admitted into evidence in this case, plus her testimony that after reviewing the file, there was no transfer or otherwise a reason why the note should be lost.
The lost note affidavit is very telling because it says absolutely nothing. What Ms. Flight's affidavit says is that the note was misplaced, lost, and or destroyed. It tells us nothing about the requirements of the statute as to whether it was transferred or whether it was lawfully seized. And or means that all of these are possibilities. It's not competent evidence of anything. And when I asked Ms. Flight whether she knew how the note was lost, and she said no, it's not correct that I then stopped. What I asked her is probably the most important thing, and that is your entire testimony is based simply on reviewing the file that you received that wasn't your file and not finding the note in there. And she said yes.
Okay,
And
you're out of time.
Thank you.
You.